to one of the stories we're tracking for you today. The Senzo Meyiwa murder trial continues today in the North Gauteng High Court. Day 2 of Tumelo Madlala's testimony yesterday revealed more details about what happened when Meyiwa was rushed to hospital. Madlala also claimed to recognize someone in the dock as one of the intruders from the night Meyiwa was shot. Madlala, who was Meyiwa's best friend, is one of 7 people who were in the house at the time of his murder. Madlala returned to the witness box when the trial resumes at 10 a.m. Let's get some analysis now from legal expert Mpumelelo Zikalala. Mpumelelo, good morning and thank you very much for your time as always. You know, the biggest talking point yesterday was the revelation by Tumelo that one of the intruders was in court yesterday, something the defense lawyers took exception to. Some analysts have gone as far as saying the state has been given too much leeway now. What did you make of what transpired in court yesterday?
And I seem to agree with them. Let's remember, the identification of a certain person, especially the accused, while they're in the witness box, is something we should be frowned upon, because you're basically saying, I've narrowed down all the other individuals to the people who are sitting in front of you, and I'm not allowing you independent knowledge and recollection to then say to us, indeed, this is the person that was the intruder on the particular day. Now, the Criminal Procedure Act is very clear as to how identifiers should be held. And in fact, in my honest opinion, I think the state was doing what the investigation officer ought to have done in the first place of saying, this is the new accused that you've been able to secure. Can you please come and want to conduct identity parades so that when you go to court, or you give us reassurance that these are the individuals that were there on that fateful night. What are they then doing by doing this particular act? Is that they are sort of trampling or contravening the rights of the accused to a fair trial is protected by the Constitution. It can't be done in a particular manner. And you could see that the state was prepared for this, let's call it an ambush, because the preparation of heads of argument, you know that there's going to be fraud.
Yeah, he preempted.
Yes, so at the end of the day, give everyone an ample opportunity to prepare, but don't do things which are in contravention of the Criminal Procedure Act. That's why it is there, so that it is able to protect and be a balancing factor for all of the participants in court. And by participants, I mean the accused and also the witnesses.
But then in this instance, though, it looks as though the state's case really is characterized by just chaos. They don't seem to have been prepared. I mean, one would think that an ID parade is one of those low-hanging fruits to eliminate any sort of confusion. You know that you have the right people. One then wonders why they didn't take advantage of this immediately when they arrested the 5 and called Tumelo at the very least to come and identify them.
It goes back to what we've been saying earlier. Law enforcement agencies and their investigation tactics and strategies. If you fail to do that properly, you're going to deliver results which cannot be used at a later stage by the NPA. And the NPA is then going to try and salvage this particular prosecution by introducing and engaging in tactics such as this one. This simply points to an investigative officer who has not applied his mind into making sure that they're able to close all the loopholes that can be there in this type of investigation. The mere fact that we haven't done so, being provided an opportunity to do so in the last 8, let's say 8, or even the last 24 months, we could have done it. But at the same time, we did not do it. And the reason being is, for a lack of a better one, maybe they were lazy. That's the one point in which they need to come in and then explain. But to engage in this particular matter, it is purely an ambush and should not be allowed by the court.
And then as far as the state is concerned, they seem non-committal on whether some of the those mentioned in Tumelo's testimony will actually be brought to testify. I mean, we're continuing to see this trend. Even yesterday, there was objection after objection, but we're getting no indication that anybody will actually be brought.
I think it's also a strategy on their part to say that I want to give you a small amount of time to prepare. So I'm not going to give you a head start by telling you who's going to come, because if I do that, you have 2 dockets in your possession. There may be conflicting statements in those 2 dockets. So you have ample time to prepare the type of questions in which you're going to ask during cross-examination. So it's better if I give you a limited amount of time to then respond in or prepare yourself, so that at the end of the day, I can at least try and establish my case. But that's not going to help. At the end of the day, the cast of the question or the assessment of the evidence is going to be weighed more based on what the person says in that particular witness box. And if there are inconsistencies, if there are clashes, then they're going to be raised during cross-examination by the defense, planting those reasonable doubt seeds that at the end of the day, they will bring out the results of saying, you know, the evidence that you've presented here is not conclusive enough. The estate did not do its investigations properly, and when it came to the prosecution, it was not done according to what a reasonable prosecutor should have done to secure a conviction in this case. So we have to let you go. We are not the guilty individuals.
It seems like it's going to be an interesting couple of days. It's almost 10 a.m. on the dot, so we will have to let you go. But thank you very much for your analysis this morning yet again. That's legal expert Mpumelelo Zikalala.